Well, welcome to the presentation today. I'd like to welcome everybody to this virtual presentation. I'm Mike McCarty, CEO of Safe Hiring Solutions. Also have Steve Koers, partner at Lewis & Wilkins law firm. We're going to talk about the top 10 trends in background screening for 2020. But before we jump in, I'm going to throw it over to Steve, let him introduce himself. I'll do the same, and then we'll jump into the workshop. Morning, Steve.
Great, thanks, Mike. My name's Steve Koers. I'm a partner at Lewis & Wilkins and specialize in a number of different things, one of them being some Fair Credit Reporting Act issues. So Mike asked me to do this, happy to do it.
Perfect. Mike McCarty, founder and CEO of Safe Hiring Solutions, been around for about 15 years. Prior to that, was a violent crime detective in Nashville, Tennessee. And let's move into this, kind of what we expect in 2020, which is a really interesting time to be talking about what to expect in an environment where most of us are trying to figure out what should we be expecting. But we're going to focus pretty squarely on background screening. And I think if there's an underlying theme to what you're going to see in 2020, based on what we've been seeing over the last few years, it is the compliancy around background screening that is going to be the biggest issue that you're going to face in 2020. This makes selecting the right screening partner extraordinarily critical. There's some basic truths about background screening and the background screening industry. It is a highly unregulated industry. And what we mean by that, those of you that are very familiar with the Fair Credit Reporting Act would think it's a very regulated industry. But as we really look at how background screening is conducted, most of the regulations about background screening have to do with dealing with negative or adverse information. So if you're not getting or receiving negative information in your background screening reports, there's very little regulation that you're going to be dealing with. And that's kind of a core problem within the background screening industry. There's a lot of focus on fast, cheap, inadequate database type searches. And so with that, it brings a whole host of problems in terms of, maybe placing somebody and not really having the full picture of what their criminal history looks like. No standard of care. That just kind of goes right along with that first bullet point when we talk about the unregulation. Across the industry, how things are defined, the way background screening is conducted, there is nothing in the Fair Credit Reporting Act that defines how you should be doing a background check in terms of what should be included. So when you're talking about employment versus volunteer versus vendor or contractor, you're comparing one background screening firm to another background screening firm. It's very difficult on the face unless you have a list of questions, which we can provide if anybody's interested. We've got a white paper, kind of 10 things you need to know before you hire a screening firm. We'd be happy to share that. But understanding you need to be doing the same due diligence on your partners that you would be on individuals that you are vetting to bring into your organization. Incomplete databases. I think that statement stands by itself. There is no complete criminal database in the United States. A lot of states and government organizations think that if they can get access to the FBI database, that they're getting a complete and true picture of all criminal cases on a particular person. Absolutely untrue. So if the FBI database is the gold standard, and study after study over the last 5 or 6 years have illustrated that it is far from a complete database, that it's missing hundreds of thousands of records, then we would also be fair to say that any criminal database is not a complete set of data. And Steve will get into this when we talk about the Fair Credit Reporting Act and reliance on these databases. There's a lot of industry that works off a 7-year standard. And what that means is they're only taking a snapshot of a 7-year period. Now, understanding if you're a global company and you're doing work all across the United States, that there are different requirements in every state, what you cannot report, how far back you can go. We have a whole templates in terms of being able to run this through a filter to know whether or not it can be reported or cannot be reported. But when you set in a state like Indiana and you're only limiting reporting of convictions to a 7-year period, the state of Indiana does not restrict that, nor does the Fair Credit Reporting Act restrict the reporting of convictions to 7 years. So even though the industry tends to move on a 7-year standard, the reason they do this, it makes it easier for them to not have to look at what's reportable in one state versus what's reportable in another state. So, I would take a look at your background screening reports and look at the small print to see if they are being restricted in any way that is not required in Indiana. I would also mention alias names. We brought on a large organization, 50,000 individuals in this organization. The first thing we noticed in the audit was they were self-relying on the individual to provide any names they've been known by, so they were using no tool to authenticate that. But a lot of screening firms, either it's not included in the package or they're going to charge you additional fees. So if you had an individual that's had 2 or 3 names, they're going to treat that as, a $20 background check times 3, as opposed to that being included in that package. So just a few things to really take a look at if you're auditing your current process, to make sure as you work through what to expect this year, that you've got the right screening partner, and that they're going to help you with any of these compliancy issues. So what does kind of a best in practice background screening look like? A core criminal package at a minimum should contain, these select items right here. You've got to verify who that person is. You're going to have to verify through the social security number. That validates not only who they are, where they've lived, other names they've been known by, that they're giving you correct spellings. We're still going to use a national criminal database, just because we said the slide previous that there's too much reliance on that. The difference is the national criminal database is a part of a package, not a standalone product. And it is a key part of the package. It is a tool that the screening firm will use to isolate and find potential criminal records. And once they find records potentially in a database, then they can send those out at the county level and have them verified with the court of record. And that's a requirement under the FCRA. You're going to look at national sex offender data. What I would also highly recommend is you're looking at federal criminal, the federal district courts. I think if you probably go back and audit your background screening program today, I would think a large majority of you are probably not utilizing the federal criminal search. If you look at Indiana, you've got county, the county courts. The vast majority of crimes are committed, crimes against the state. They're going to be in the county of record. Happens in Indianapolis, Marion County, Hamilton County. The federal, we've got 2 jurisdictions in Indiana. You got the northern and the southern. These are crimes that typically are investigated by federal law enforcement. These are interstate type crimes, but you're starting to see more computer-based solicitations, drug-related cases that are crossing state lines or joint task force. This is a fairly inexpensive search, but it is a very critical search to be part of your core package. And these days would be more of a requirement than it was even probably 8 or 9 years ago, where we would only do this for financial institutions. And then you're going to look at additional solutions. If the individual is going to be driving, we want to make sure we're doing a Bureau Motor Vehicle check, potentially look at an employment credit report. But I can tell you, if you ask for this solution we're going to ask you a bunch of questions to make sure this is a tool that you absolutely need and understand, and you got a business necessity for that. But it can be a very good tool in, a CFO, in positions that have fiduciary responsibilities. Continuous checks. We're going to talk a little bit about this in a moment. Employment verifications, verifying that they are being honest. They have worked in these places. The character reference or reference checks. This is another piece we're going to talk about in a little more detail in a little bit. It's a part of a screening program that I think has gone by the wayside in the last few years, but it really is a critical piece of screening to be able to talk to references and gather additional data. So let's jump in here, talk about these 10 trends that Steve and I have put together to really keep an eye on in 2020 and understand in a little bit more depth. Not shocking that the number one thing we're going to lead off with is, coronavirus or COVID-19 and what impact on screening it's having. Well, it's having some wide impact on background screening. The national organization that we belong to are working diligently because you have all these court closures, and we've got a maximum accuracy requirement, meaning I just said on the last slide, if we have a criminal record, we need to verify that with the court of record. How do you do that when the courts are closed? We're extraordinarily fortunate in our company in that we've integrated with the vast majority of courts that have electronic systems, but we still have places where we're relying on individuals to be able to access those courts. So how do we verify and access those court records? Cost in a tight economy. I can't imagine anybody on this webinar or workshop today is not seeing some kind of decline in business. There's a select few markets that may be actually seeing some explosion in business, but the vast majority of us have seen some cost tightening in our organizations because our revenue has gone down. And so we've been creating, pre-COVID, we were creating stair-step solutions versus one large, huge package. If I'm hiring individuals in a transportation position, I could probably lean out and move first with running a motor vehicle check. If the motor vehicle check comes back and it alone would disqualify based on your policies, then why should I spend $45 for a background check when I could have done that for 10 or less, depending on the state check? And then we have added some pre-search solutions where we've integrated directly with some jails and arrest institutions across the country where we can quickly run through and you could place people, even with these court closures, if they come back clear. And then if there is a trigger or a hit, then it would spawn us going to that court and verifying that record. So a lot moving around COVID, and we'll see continuing changes as the country hopefully starts to go back to work. Some of the courts start to open back up, but there's going to be gaps in that data that needs to be updated, and just understanding how that's going to impact your reports. Now I want to talk about consumer privacy concerns. I'm going to toss the ball over to Steve on this one.
Excellent. Well, thanks, Mike. I appreciate it. So as we go forward, you're going to see a lot of different jurisdictions try and kind of tighten the belt on privacy, as it were. And the first of those, the first big domino to fall on this is California. Just at the end of 2019, went into effect January 1st of this year. California passed their California Consumer Privacy Act, or the CCPA. Sort of the genesis for this is so the data aggregating companies such as Google and Facebook would just have all this data out there, and then other people would do something with it. Think about the Cambridge Analytica issue, where they'd had like 87 million people had their profiles reached, and only a couple 100,000 of them had any notice of that. And then it's subject to targeted ads by different campaigns. There was another thing with I think it was 23andMe, the so the hereditary thing, they gave access to a big pharmaceutical company. They de-identified the DNA of millions of customers, but they still had that kind of data. So California took action and pretty much tried to limit what people could do with data of California residents. And we bring this up because, if we go to the next slide there, Mike, we talk about it a little bit, but kind of bring this up just because it affects California, but other states are going to start using this, kind of make it sort of a template as we go forward. And California being the most populous state in the country, it affects their residents directly. So a lot of companies have sort of determined at this point, if we're going to have to deal with California anyway, we might as well handle their data process the same way. So it helps out a little bit for everybody. So here's the rule for it. So if you are a for-profit business, you have to have a CCPA compliant privacy policy if you have $25 million in gross annual takings. That's the word, takings. So whatever you have, it's $25 million. If 50% or more of your revenue from selling data belongs to Californians, or if you distribute, process, or receive data from 50,000 or more Californians annually. So if you think about big companies, Google, Facebook, whoever else, if you have a website, that's kind of what this really applies to, but if you have a website and people are accessing it, if more than 50,000 Californians access that data, then you have to comply with California's privacy policy. It can be kind of stringent, and that's, this is why it affects everybody all over the country. So there's sort of what we call them, like 5 big areas of protection that California has to have, and this in its own right is a larger topic. I mean, so we're going to go really quickly through the California Consumer Privacy Act, but it's probably worth its own webinar at some point. But just in general terms, they kind of deal with certain information, personal information, which is name, address, social security number, all that kind of stuff. But it also includes biometric data and your browsing history. So all of this stuff is what they call personal information. Anything that can link to you is PI is what they call it, right? So it also identifies person or a household. So it's more than just an individual. It can be the entire, everybody living in your household. That's the data that comes in. And as far as background screening processes go, it doesn't include anything that's publicly available. So court searches, things of that nature are accepted from this. So it may or may not affect individual companies as much as others, but again, this is something that's kind of coming down the road. And also there's what California has done is give everybody a right to know whether their personal information is sold, disclosed, and to whom. So that's on the next slide. You have, as an individual in California, you have the right to know whether your information is there. California is a little different just because they have to disclose what they call categories of information. So you don't have to say which third party that you are disclosing information to. It's more of what type of category. So, it could be, we have, if your website is given data to, a pharmaceutical company, that's all it would be. It'd be like pharmaceuticals would be the category. But so people have a right to know kind of where that information is going. The problem with this, and this is a little bit different than the European solution, which we'll show in a second, which is sort of more upfront. If you have data in Europe, you have to actually take actions on these things. This is a person themselves has to make this particular action. So they have to notify the company, take my information down, that kind of stuff. So, and that's the next slide as we talk about, you have the right to opt out of the sale of your personal information. So you have to physically take action and click on some certain links. And that's what California has required, is that you have to have an actual link on your opt-out page, not just a check mark, but you have to be able to move that screen to another one where you actually can fill in the information, and you have to opt out, and the businesses have to honor that. There's no exception on that. But they can sell the information if the personal information is removed. So if you kind of de-identify it, they can still sell that information. So some of the things that they wanted to do couldn't quite get everything through in that regard, because there's still some ways of getting around having your personal information as long as you could de-identify it and that kind of thing. So and the other part of that is like this impact that I note down here is that you can't opt out of the business collecting your information in the first place. So if you go on a website, then your data, your browsing history, all that kind of stuff is collected automatically, and you can't opt out of that. It's going to happen. So, so that's kind of why the impact is a little bit different, because Google and Facebook can keep doing what they've always been doing. So they just can't identify you personally. Okay. So the next sort of issue with California is you actually have a right to access your personal information, and you have a right to be forgotten. So you can, the business has to give a way of collecting that personal information. And if you ask for it, they have to give it to you free of charge, and they have to give it to you within 45 days. There are certain exceptions where they can extend another 45 days, but they have to tell you that. But in any event, they have to give you your information within 45 days. They have to tell you what type of information, where it came from, why they collected it, the categories. Again, California's issue is calling them categories of third parties, not individual third parties. And then what exactly they did collect. And then you as an individual consumer have a right to tell that business to delete that information completely. So it's a little bit different. And I think this is kind of where things are going to start going, because most states are starting to get concerned with what kind of information big giant corporations are accessing. So, and then the last one, excuse me, is just a sort of a non-discrimination portion. So if you tell somebody you don't want that information, then the company can't discriminate against you. So you have a right to the same service, same privacy rights. They can't charge you extra, can't refuse to give you anything, but they can offer you bonuses. So, or incentives to say. So there could be some people who want that information as long as they get something in return. And then like loyalty cards, gas cards, those kind of things, those are accepted from the California definition. So a little bit different from the general data protection regulation. And this again is a whole nother webinar we could get into, but point being is that Europe has their own particular way of dealing with data that is collected on their European citizens. So if you have users in the European Union, there's certain particular laws and regulations that you have to follow if you're a company that has a website and a presence over there. The main point is what Europe's trying to do is that if you want to give consent, you actually have to understand what you're doing. So you have to freely give it. It has to be informed and unambiguous. So think about your general terms of service checkbox that you would have. Like, yeah, I've read these terms of service, click, all right, on and on and on. And in Europe, that's not enough. You can't just click this particular little box and move on. You actually have to give the consent that you know exactly what's happening. So it sort of incentivizes companies to minimize the amount of data that is out there. And so the idea was like basically people were kind of, if people were put off by a clear explanation of how their information is being used, then that particular behavior would theoretically stop. So again, Europe has this GDPR has had a whole bunch of different impacts. It's not been as clean as they would like it, and it's still moving forward today. But if you have business in Europe, kind of the upshot is you're going to have to kind of comply with their particular guidelines. So, and we're going to quickly go through this because this is really deep if you want to get into it. But here's what you have to know if you're in the GDPR. Does your business website collect data or info from users in the European Union? Does the business have more than 250 employees? It helps because if you have more than 250 employees, there are stricter regulations. If you have less, then you don't nearly have to deal with as much. And then they have, is your business a data controller or processor? And now these are big defined categories, but if there are different treatments that happen with each one, if you're a controller of information, you have to kind of deal with different regulations. We'll talk about that here in a second. And then does your business collect personal or sensitive data? So we move on to the next one real quick. so if your business websites collects data from European residents, again, you have to have this consent. All companies that process data of European Union people must comply with the GDPR. And you can see it affects the big companies. If you do business over in Europe, you really have an impact on this. And you have to minimize the type of data that you do collect. So the big thing is, like, if you're in the United States, as long as you offer goods or services to subjects in the European Union, you have to comply with this particular regulation. So again, and we'll just go real quick through controllers or processors. These are totally different ideas. So if you, so here's kind of the general upshot of it. Controllers are processors of data that are located in the European Union. It also applies to controllers or processors of data who are not in the Union, but if they offer goods or services to subjects in the Union or monitor their behavior. And also applies to controllers or processors of personal data not located in the Union who are member state required. So if you're in, and I can't remember exactly which states require it, but certain countries require you to comply with the GDPR anyway. So, and we'll go to the next one real quick. Here's the definition of controller. You can see it's a legal person, authority, agency, or other body which determines the purposes and means of processing the personal data. If you are one of those, you have to implement certain data policy protections, adhere to their code of conduct and their certification process. And a controller is different than a processor in that a processor is a natural or legal person, authority, agency, or other body which processes personal data on behalf of a controller. So it's a little bit stricter issue that we have to deal with. So you have to keep more detailed records, have a comprehensive compliance and security technology, appoint a data protection officer, which is kind of the big thing with this law overall. You have to have an individual who's in charge of, what data is out there, who's that person's the contact with an individual who has a question. That person also should be training your staff and also dealing with any other sort of issues that come up. And you have to have you should basically conduct impact assessments. How's your data protection policy working with your website, and have a notification of breach of procedures in place. So again, if we go to the next one, yes, so this is kind of what it deals with. It's collecting the personal or sensitive data. You can see that personal identified is a little different than a California system in that it includes everything, the identification number, bank details, home and email address, all that kind of stuff. But sensitive data is more of the biometric, genetic, health, sexual, religious, philosophical, those kind of things that California all clumps into one particular grouping. Here in the GDPR, they're categorically broken out. So it's a little bit different. I'm not sure which one we're going to go with, but I imagine California is probably going to be the standard as we go forward. So the difference between the two of them, again, at the very end of all this, is that the CCPA does not require companies to go through all these steps to collect personal information. So any limits on data will be imposed by individual users who make those requests to delete and opt out. In the GDPR, that's automatic. You have to go through all of these data protection procedures. So it's kind of depth and a quick kind of run through of what exactly these particular things are. Kind of want to give you just a little taste of it, but these are the things that are coming. You're going to see more and more companies, more and more states, I should say states, and trying to force companies to comply with particular data sets. All right, and then so the FCRA compliance is another big issue, and I know Mike's talked a little bit about this, but here's kind of just the gold standard of what we have to do as far as background screening goes. Background checks are considered consumer reports. You have to have a permissible purpose. There has to be an authorization. We'll talk more about this in a second. You have to notify people if you're taking adverse action, and Mike could probably attest this as well. This is where we see a lot of confusion with employers not really understanding what adverse action is and what they have to do. That's really where most of the lawsuits these days come from, is failing to follow adverse action procedures. Recently, in just this last run through. In 2018, they amended the FCRA a little bit, and they added specific identity theft procedures that people have to follow, and then ways to address any discrepancies. So the big thing, and there's a lot to the FCRA as well, but kind of the big thing as we were breaking this down a little bit is just figure out what is important for employers to really know. And that is, you have to get consent on everything. And it has to be a clear and conspicuous authorization that's in writing before or as you get the report, and in a document that's solely of the disclosure. This is another big issue that's been popping up a lot lately in the courts, is that people will get authorizations, but they will also start throwing in things like liability waivers or explanations of things like maybe there are different states that have, and there are different states that have certain requirements, but if you throw that on your disclosure, that can be a problem. So the whole point of all of this is that the government wanted individuals to have an idea where their policy or where their privacy information was going, but also knowing what exactly they were getting themselves into. So they want it very clear, very conspicuous, and very plain as to what exactly these disclosures should take care of. So again, as we see, the big kind of thing that we're going to deal with is adverse action on these issues. So we'll talk more about disclosures as we get into the lawsuits here in a second, but the big thing that we notice a lot is that when you have adverse action, if something comes up, you're interviewing a subject who comes for possible employment, and there's something you don't like that causes you to not take action, not hire them. If we go to the next slide real quick, you have to do two separate things. Okay, yeah, so yeah, there it is. Thank you. So you have a pre-adverse action notice that you have to give, and then there's an adverse action notice. So two separate things. A lot of companies we've seen have only done one, and that's after they've taken action. And that can get you in some serious trouble. That's where, again, a lot of lawsuits happen out of this. So a pre-adverse action notice has to happen before you do anything. So if you get information from your credit reporting agency, your background screening firm, you have to notify the individual that you are considering action that is unfavorable to them. So say, I'm not going to hire you. There's, something's popped up in, your credit report, the background screen, can't hire you now. So you have to give them that. And what you also have to do is give them a copy of the report and the FCRA summary of rights, which is like a 3-page document that tells you everything you absolutely need to know to how you can respond. So, and you also have to give what the FCRA calls a reasonable time to review or dispute that information. And in general, of course, have said that's about 5 business days. Now, it could be higher, it could be more or less depending on the process you have and whatever. But they have some exceptions. But for general rules, you got to give them within 5 business days. And then after they've had an opportunity to respond, you can go ahead and give them your actual adverse action notice. So you can say, no, we're not hiring you. And the reason we're not, we gave you the report before. Now here's your credit reporting agency's address and information. You have to actually tell the individual that the credit reporting agency, the background screening firm, did not make this decision. It's amazing how many times people try and say that the background screening firm is at fault for not hiring somebody, which is kind of strange, but it does happen. So the FCRA makes sure that the employer has to tell the individual that the screening firm did not make this decision. You have to also tell them that they have a right to receive the consumer report for free, which basically all the information that's in the the background screening firm's file, and file is the term that's used. So you don't have to give them everything, just whatever you collected. So if you've seen it, you don't have to give it to them. I know this has come up a few times, but it's just basically an electronic file with certain information. It doesn't have to be everything. So, and it has to happen within 60 days. So, and it also gives them the right to dispute that accuracy with the background screening firm. So, so the big thing, there's an exception, if you have, you don't have to get notice, authorization, or provide copies of documents if the report was sought for employment purposes and you have some suspicion that somebody's done something wrong. So if you're having a continuing background screening firm or background screening policy that you're going to keep checking on them as they're employed every year, every 2 years, whatever it's going to be. If you have a suspicion that somebody's doing something wrong, you can go ahead and you don't have to use the adverse action process. So that gets us into a little bit of some of the lawsuits that have popped up in regard to the FCRA. Just as a general rule, you've got negligent violations, which can include actual damages, which again can include some emotional distress. So if the background screening firm isn't, just absolutely accurate, misses something that's negligence, that kind of thing, that can be some actual damages. If it's willful, if either the employer or the background screening firm does anything that is intentional, you can get actual damages plus statutory damages, which is $100 to $1,000 per occurrence, and more importantly, punitive damages, which nobody really wants. So a couple general categories of lawsuits that we've seen a lot lately. There's this Spokio versus Robbins. It's a U.S. Supreme Court case in 2016. Class actions have been a big problem in this area. You have, hundreds of thousands and sometimes millions of people who are involved in these class action suits. This one involved an individual who went online to Spokio's website, which is just a people search, like, one of those quick, free, easy ones you see online. How put in somebody's name and it'll give you whatever public information that the website can find. And they had something that was inaccurate. And Mr. Robbins filed a class action, and a lot of times people would settle these cases, and Spokio took it all the way up to the United States Supreme Court. And basically the court ruled that you have to have an injury in fact, bear violations of the lawsuit, or the regulations aren't going to necessarily spark any sort of liability on these things. So if you had just a technical violation of the statute, then they're not going to let you just make a claim if you don't have any particular injury. It's a big deal because there's a lot of people that make claims on these FCRA violations that the company didn't do things exactly to the letter of the law, and they would end up being fined by the FTC or the Consumer Finance Protection Bureau. Those kind of overseeing commissions, they would fine people, and then you get all kinds of big dollar suits. So sort of the whole idea of all this was like, if you don't have a real injury, we're not going to consider you to be able to make these particular claims anymore. Now there have been a few cases that have come around that have sort of hearkened on to the Spokio ruling, and you basically have, this is just last year. So you had a case in Virginia for Wells Fargo. People went onto their consumer report portal, and they, I guess there were some objections to language that were in there, but the court said there's no injury in fact, and that wasn't traceable to Wells Fargo, so that wasn't going to be addressed by the court. Walmart this is a big one, had a $6.5 million class action suit in California. They added some extraneous information to their authorization, not enough that was really objectionable. It was just more bare procedural violation. So the court rejected that particular case. And it's been a big help. The Spokio case has really sort of knocked out a lot of these things, but a lot of companies would rather settle some of these things than deal with some of the uncertainty that's kind of going around. So if there are like more major violations, so if you do, and the big one is if you include a liability waiver in your authorization, that's going to get you every time. And so a lot of different companies have decided they're going to go ahead and try and settle these things. And there are more and more of these settlements popping up. So I'm not really sure what the impact of Spokio is, other than if it's just a minor technical violation, it's not going to be actionable. But if it's something a little bit more, and what that little bit more is what the courts are dealing with right now, trying to figure out how you're going to redress those issues. So The other big one that we kind of see a lot of are these standalone requirements. As I mentioned a little bit before with sort of just the general FCRA, if you have to have a disclosure document that consists only of that disclosure. So you don't have liability waiver, you don't explain different rights in, like, say, California, Texas, wherever it is, New York. If these states have different rules and ban the box things and all those kind of things, if you put a little checkbox in your liability waiver, that's going to be a violation of the standalone requirement. And it has to be clear and conspicuous. So it can't be something where you add extra words in there and people don't understand, because there have been lawsuits that do find that if you add something in there that makes it unclear to the individual, then that can be a violation of the FCRA. So just in general, there are some quick kind of examples that we have. So the failure of the standalone disclosure cost 7-Eleven and Costco some big money, 1.9 million, 2.5 million, respectively, as to how much they paid out in these class actions. Petco, so this is sort of an example of what the disclosure was. It was unclear because it said any person can provide any and all information to a credit reporting agency, and that's extra language that was added in, and courts found that to be, well, actually, the Petco understood that was going to be a problem, and they ended up settling that particular issue, and also had 7 different states on there. So again, kind of make sure your disclosure is standalone. I know Mike's company definitely has a very solid standalone disclosure, but a lot of people don't. So another one was, Omnicare had a $1.3 million class action by settlement with enclosing a liability waiver. Frito-Lay had a disclosure, but they also linked to marketing web pages, and that's definitely not acceptable, and rightly so. They ended up settling that one. And then there's another Delta Airline $2.3 million class action. So you can get into a lot of different issues where you can, if you violate just some of these FCRA regulations, you can really get yourself into some big trouble. So that's the big one, kind of the real big trend that we see in the last couple of years. It's not just 2020, the last couple, and it's going to keep going on as more these companies do this. Okay. Yeah, and there's just another. I did want to just bring this little thing up, because this is it's an ongoing matter. Mount Diablo Lending out in I believe it's in California or West Coast, but an individual customer gave a bad review on Yelp, and the lender owner started posting replies on that one with specific information dealing with this particular individual. It's like, yeah, well, you've made late payments, and you have a high debt ratio, and you have questionable business deductions, those kind of things, and that's a pending lawsuit. But those are the kind of things you can't do if you're a company. You cannot respond to claims like that. I imagine this one's going to be a pretty interesting settlement. They can't go forward with that. So, right.
Ouch.
Yes, exactly.
Ban the box. This is another one that's kind of hit Indiana several years ago and has kind of morphed and changed a little bit over time. But to understand ban the box, it's a movement that's been spreading across the United States for many years now. And the idea behind ban the box is kind of twofold. The basic premise is, the theory is that those with a criminal history, ex-offenders, are being kind of disenfranchised in a sense, because if they report on an application that they have a criminal history, then the theory is they're not getting past that application process. And if they don't have to disclose that criminal history on the application until they get to an interview, then they're more equipped to be able to explain that criminal history during an interview, which then may not preclude them from being employed. So it doesn't preclude discussing or asking questions about the criminal history. It just delays that and removes it from your application until you get to the interview process. And Steve, I'll let you kind of give them a little foundation on this statute here in Indiana, if you would.
Sure. Yeah. It kind of, so Indiana has a new law that we sort of put together where, local governments started to kind of take some control over what records could be discoverable and what they couldn't. And you had a huge, disparity. Like Indianapolis would have a law, and then Evansville would have something, and Terre Haute and Gary would have all of these separate, what you can and can't do. So Indiana just took control over all that and kind of made it one big particular statewide laws of what you can and can't do with regard to ban the box. And it's more of a, some people thought it was directed at Indianapolis because they had a particular issue, and to some degree it kind of is, but overall it's good for all of us because there's just one rule now that we have to deal with.
Perfect. Social media. If I put out a survey of our clients, I would probably have very few that check the box that they're doing this. But right. With many of my conversations, I would say what we see with this Career Builder survey probably replicates what I hear when I talk to some of our clients. And what they found with Career Builder is, 70% of employers are using social media with candidates. Steve and I could tell you about a case with one of our clients, and a quick Google would have uncovered the world on what this guy had done in a very different part of the country. So understanding the premise and why that employers, potentially are looking at this information. Career Builder is pretty straightforward. 70% of employers say they're using it with candidates, 43% using it on current employees. 57% have seen content that caused them to eliminate a candidate, provocative, inappropriate contact, drinking, using drugs, discriminatory comments. Obviously, if you have any social media these days, I've almost quit looking at anything on social media because of everything that's going on. So the amount of information that people put on social media, you can see why it's very attractive, as an employer to be looking at that. But, it does raise some concerns. Are you viewing any kind of protected information? Because certainly in social media, depending on the different platforms, you are seeing or reading information that may be protected information. From a background screening firm perspective, one of the things that we look at is you've got this kind of maximum accuracy requirement under the Fair Credit Reporting Act. Well, how do I verify this information? How do I know that the John Smith that we are looking at in social media is the John Smith that we are have as an employee or a candidate? So how do I verify that? We don't typically have a lot of PII associated with that. How do you know, and even from more of a former law enforcement detective perspective, one of the cautions I would have as well is some kind of false assumption if you're doing social media checks and you're looking that because I don't see anything that doesn't necessarily mean there's nothing there. Let's think in terms of, more sophisticated people online, your predators. They're not operating under their names online. And so, I don't know if you have any quick points, Steve, from a legal perspective you would want to make as it relates to how you should be doing this if you are in fact doing the social media checks.
Right. And I think social media is a helpful tool. You can definitely wipe out some people just by kind of doing a quick check. But in the one case that Mike and I were talking about is that, a Google search found like the top 5 things were this particular guy, and the employer was trying to blame a faulty background check. And you go, that's pretty simple to go through it real quick and figure out that this guy has some issues with him. But then in other cases, like when you have a John Smith, you just don't know. You have to have a more detailed to search on that. So you need more information. And I think legally, it's probably nice to get much more information as you can. Do a background check. They can go through and find out much more stuff than you can on your own.
I think I've heard in the past that, if you're going down this path, maybe outsource it to your screening firm so they're filtering the data. And I've even seen organizations that have policies internally where somebody outside of human resources is actually doing this so they can remove a lot of that protected data.
Exactly.
So a lot of these topics we probably will follow up with more one-to-one webinars, because with a little bit limited time coming up, we're kind of racing through these, but there's a lot of discussion that can happen. Continuous monitoring. This is a big one in 2020. I say that because I think this one changes the whole fabric and game plan for background screening. With continuous monitoring, we launched a service proprietary called Arrest Alert. And what we did was integrated with about 90% of the booking or jail institutions across the United States. I've known for 15 years, since I started Safe Hiring, that the minute we conduct a background check, that background check is a historical document. Case in point, Marion County, 2 employers, candidate applies to one employer, goes through a complex mandated by the state background check, comes back clear. They don't move very quickly on hiring, but 3 weeks later, this same candidate applies to another organization in Marion County, and at that point comes back with a pending case for child sexual solicitation. So it shows how quickly in a 3-week period a background check can change. So what we've launched about 12 months ago is a program for continuous monitoring. And so it gives real-time triggers. Somebody gets arrested, you're going to get a real-time trigger. Now, the way this should operate is it's not once you get that notification, a termination. I mean, I think Steve walked through this very clearly on the FCRA requirements. An arrest alert, we discuss this as it's a whisper alert. This is no different. You pick up the newspaper. It's no different than somebody calls your office and say, hey, John Smith was arrested over the weekend. What is your policies moving forward? We're going to give you a notice. You're going to see data where they were arrested, and then it's your internal investigative policies that then start at that point. What this can do, it's a very inexpensive solution. It also can reduce the cost of ongoing background checks. Because if you're a company that's doing one background check when you bring them into the organization and you're never doing anything from that point forward, you're really placing, a lot of risk on the organization. For example, in Indiana, about 3 years ago, the state of Indiana mandated across the state that all schools, public and private, have to do a background check every 5 years on employees. The difference here, if you're doing this from a policy perspective, you're talking a few dollars a year per employee versus doing a complex background check every 2 or 3 years. It's going to, one, close the gap and give you all-time, real-time, continuous, so you deal with it the moment it happens, because it's going to send your team a real-time trigger or an alert. But it also can have some, fiscal impact in that it's a lot cheaper than doing complex background checks every year, 2 years, or 3 years.
Right.
Reference. Oh, go ahead, Steve.
Just to jump back in on that one, it does trigger your own individual internal policies. And if something like that were to happen, you still really need to come back and follow some of the pre-adverse and adverse action stuff from an employer perspective. I think that's the best way to keep yourself safe, is to go through that process as well.
Perfect. Whoops, went the wrong direction. My fault. All right. There we
There
go.
you go. Yep.
Mouse quit working. Reference checks. 2 or 3 years ago, Wall Street Journal did a big article, and several large employers in the United States did what they called a mass one-day hiring. And with that, they kind of, one of the big things they did was remove the reference check process. And really what this was saying is reference checks take so much time that it's impossible to get people placed quickly. We're going to do away with them and see if we can place, tens of thousands of people in a one-day period. And so it was a fast track hiring. Now, clearly you go back and review that 2 years later, and even experts at the time were weighing in saying there'll be a negative impact on this, a year or two down the road. So the premise was, hey, these traditional reference checks, I'm having to pick up the phone, call references, talk to individuals. They're not calling me back. Business to business policies, name, rank, serial number are applying here. They're not giving me any information other than, yes, they worked here this period of time, and they left on this particular date. Even in places I know like California, which is a totally different topic we're not going to get into now, even asking about salary and questions related to that can have an impact in whether or not you can ask that. So, looking at automated tools, RefLink is a tool we built 6 or 7 years ago. How do you automate that process? It comes from the candidate. It's text-based or SMS-based. So looking at alternative ways of gathering that information that really oftentimes is much deeper and more complex and comprehensive than picking up the telephone. It's all candidate driven. So it comes from Steve Koers asking you to provide feedback, not from company A, B, or C. They can provide the information anonymously. The surveys can be built on very specific competencies for the position. And so, as you look at your screening program and evaluate it, if you're one of these companies that have pushed reference checks off to the side, it may be time to look at one of these tools that can automate this process and can do it for very inexpensively to provide a lot more data. Even on the criminal history side, if you're an organization that has volunteers, we have a large number of volunteer organizations. And we know that some 80+% of sex offenders do not have a criminal history in the United States. Why? Because they've never been caught. They've never been arrested. And so if you're an organization where a sex offender can have a huge impact on, children that you serve or the elderly or whomever, then you need to be using tools other than just a criminal history check, because a criminal history check alone will not disclose 80% of the sex offenders in the United States because they're yet undetected. Reentry and second chance programs. We've talked through this with some of the, ban the box information. There's lots of incentives, programs all across the United States really geared toward what's the best path to reducing recidivism and gainful employment. Some of the EEOC concerns that also fall into this category, which I'll let Steve, you kind of talk through a couple of these.
Yeah, just real quick, because it's so absolutely important to keep following the EEOC regulations. So you can't check background on applicants when and make hiring decisions or firing decisions when those decisions are based on the protected classes, which are race, national origin, color, sex, religion, disability, genetic information, or age, which is now it's 40 or over, which seems kind of strange, but that's what it is. So we're all protected class now. But so you can only if you ask only people of a certain race about their financial histories or criminal records, that can be evidence of discrimination. So you got to be very careful when you're dealing with your EEOC issues. So You have to apply the same standards to everybody. So again, here's just a quick example. If you don't reject applicants of one ethnicity with certain financial histories or criminal records, you can't reject applicants of other ethnicities of the same situation. You also have to you have to prepare to make exceptions for problems that are revealed during a background check that were caused by a disability, things of that nature. You can't exclude people. So if somebody has a disability, you have to allow them they're able to demonstrate that they can do the job. There's some different EEOC claims that have happened. Big historical ones. Ford Motor Company gave out psychological tests that were discriminatory against African Americans. They had to pay $8.5 million. There's, as you can see here, Dollar General, CXX, all had disparate impacts on African Americans, females. Crossmark had one recently. This is just last year. $2.6 million settlement for not accommodating people with disabilities, and that policy was basically they had a rule that an employee could sit for no more than 10 minutes every 2 hours as a marketing thing, like you're giving out samples in a grocery store or something like that. You can't sit for more than 10 minutes. Well, people with disabilities proved that they could do the job if they sat there, and they ended up having to settle that thing for $2.6 million. There's a whole bunch of other ones. Another one's Equal Pay Act. Make sure you pay people equally for the same job skill. These aren't nearly as big because they're not class actions. They're more individual judgments and settlements and that kind of thing. But there's a female physician who was paid $115,000 less than her male counterparts, and ended up suing. Cummins right here down in Columbus had a female performing the same manufacturing work that was paid significantly less. So as you can see, you go through all these different types of Equal Pay Act violations that are going to keep popping up.
And lastly, number 10 is really looking at, HR technology. We see this across all spectrums, but everybody is managing typically lots of disparate systems that don't communicate or speak to each other. So it's really creating solutions that are integrated, that can communicate, where you can manage things in one platform, automate processes where you can automate them, remove, human error, keystroke entries, or, duplication in labor. So, really, evaluating what opportunities you have for, integrating your HR technology solutions together. Let technology work for you alongside your employees. And then really the technology allows you to kind of do some of these stair-step packages, like I mentioned earlier, running the pre-searcher MVR step 1, and, getting a green light, red light as you review that before you then move on to the rest of the screening package. So being a little more fiscally responsible, especially in this climate where a lot of your income may have taken a huge hit during this COVID-19. And it's just another way of being able to do this, do it in an effective and appropriate way to save some money for the organization, but also being able to add some solutions that bring a lot of value to the organization. So letting technology work for your organization. I think Steve and I probably both feel like we have flown through this. He and I both are much more interactive. So doing this as a, stand behind the podium or computer screen webinar is a little different for both of us. We like to interact and take questions throughout the presentation. Didn't have the opportunity with this pandemic. So here's all of our contact information. Certainly, reach out to us, phone, email, questions. If you're wanting more information, a deeper dive into any of these topics that we presented here, we'll probably be offering some deeper webinars on individual topics, but we appreciate your time today. Look forward to hearing from you, and have a great rest of your day.